Hello, I'm Georgina Jalbo from Lexis PSL Private Client, and this is Toby Crooks from Rawlinson Hunter, who has come to provide us with an update on UK Res non-dom issues, in particular the very current and political issue of non-dom status. So Toby, thanks for coming in. Before we get into the detail of the recent changes and proposals, for the benefit of those who don't deal with these issues in their day-to-day practice, can you just outline the benefits currently attached to non-dom status?
Certainly. The key difference is that whereas a UK domiciled individual is taxed on their worldwide income and gains, a non-domiciled individual has the option to elect for the so-called remittance basis. And essentially what that means is potentially indefinitely their non-UK income and gains can be sheltered from UK tax until such time that they bring those funds, i.e. remit them to the UK. Mm-hmm. The other significant tax advantage that non-domiciled individuals has is a favourable treatment for inheritance tax, and broadly speaking they're only taxable and liable to tax in respect of their UK situate assets, albeit in that particular instance, once they've been in the UK for broadly 17 years, they're taxed much like any other UK domiciled individual on their worldwide estate. Although having said that, conventional planning has been to establish so-called excluded property trusts before that deeming of domicile. Yes. And effectively in that way it has been possible to continue that sort of favourable IHT treatment.
So clearly then an extremely favourable regime for non-doms, but I understand there have been changes to the rules and more changes are in the pipeline.
That's right. I mean, really these changes can be traced back, I think, to the far-ranging reforms of 2008, and in particular for the first time then non-domiciled individuals who were so-called long-term residents in the UK, i.e. those individuals who had been here for 7 tax years, had to start paying a £30,000 fee in order to enjoy the benefits that we've just been discussing. And subsequently in the 2012-13 tax year, that £30,000 charge was increased to £50,000 for individuals who had been resident here for 12 years. And roll forward to the current tax year, and what we're seeing is that £50,000 charge is being increased to £60,000, and also the introduction of a new tier of charge, a £90,000 charge for individuals who have been resident in the UK for 17 years. And you'll see there that there's essentially been an alignment between that highest tier of 90,000 and the point at which those individuals would be becoming deemed domiciled for inheritance taxes in any event.
Yes. And what about the further changes in the pipeline that you mentioned?
So, in addition to these changes in the RBC, which are definitely happening, the government has also been consulting on a proposal to lock in the users of the remittance basis who pay the remittance basis charge to a set number of years, so 3 years, or possibly even 4 or 5 years in the cases of those individuals who have been resident in the UK for 12 or 17 years. So that would be a very significant change in the operation of the beneficial non-dom rules, and in particular it would be an erosion of the flexibility that a non-dom taxpayer currently has. Say if they were realising a substantial non-UK gain, at the moment they could elect to elect for their remittance basis a remittance basis of taxation, pay the 30,000 charge, say, and shelter that gain, yes. i.e. defer immediate UK tax, and then in subsequent years revert to the arising basis of taxation. Clearly, if they're locked in over a longer period of time, then that is going to make a sort of significant difference to certain individuals.
Yes. Right, that's very clear, thank you. Presumably though there's now the prospect of further changes depending on the outcome of the general election in May.
Absolutely, and I'm sure that many of the viewers watching our discussion here will have been aware of Ed Miliband's announcement that Labour intend to abolish the non-dom rules. Albeit as that particular story developed, it became clear that some kind of favourable tax treatment for internationally mobile individuals would be preserved, perhaps for people who are in the UK for 2 to 3 years. Although Ed Balls has said, in his view, 5 years would be too long in his opinion. The analogy that was used actually was broadly the length of a postgraduate degree.
Yes.
But in any event, Labour have said that if these changes were to take place, they'd take effect from April 2016, so the 2016-17 tax year.
Right. So is this just electioneering, or is it a real possibility?
Well, I think it's probably a bit of both, actually. Although what I think is clear is that irrespective of which party or which parties are in government following the election, I think it's quite likely that there'll be further erosion and curtailment of some of the fiscal advantages that non-domiciled individuals have enjoyed historically. So I think that is the established trend, and I would expect that to continue. In terms of the impact that will have on our non-domiciled clients, I think it's going to vary. In some circumstances where the individuals are already deemed domiciled for inheritance tax purposes, and where for a number of years it's not been economically worthwhile for them to pay the RBC, i.e. they've been taxed like ordinary UK domiciled individuals in any event, then the changes are going to be quite negligible, really. But in other instances, particularly for those 5,000 odd individuals who we know pay the RBC and presumably have substantial non-UK income and gains, I think inevitably it's going to make the UK a less attractive place of fiscal residence for them, and possibly their businesses as well. But we'll have to wait and see, I think, really.
Yes.
I mean, what is clear, though, is I think that we're going to have to live with the legacy of the remittance basis for a number of years. If it were to be abolished, I mean, there would be a requirement for transitional provisions and a way of dealing with all of this non-UK income and gains that has historically been sheltered by the remittance basis. So as practitioners, I think we'll have to continue to deal with it for some time. And I think the final thought, I guess, that I have on the possibility of these changes is, will we see a trend in the direction of high net worth and ultra high net worth clients who previously would have considered becoming UK resident, taking advantage of the non-domiciled favourable rules? Will they instead, using the increased certainty under the statutory residence test, organise their lives in such a way that they can have a reasonable degree of certainty that they'll be not resident in the UK, and therefore continue to enjoy the sort of lifestyle and sort of business opportunities that being in a global city like London can afford them? So
yes.
It's interesting times.
Yes. Well, it'll be fascinating to see how this area continues to develop, especially in light of the election in May. Thank you very much, Toby.